All right, well, welcome everyone to the class on should my client own their real estate in their individual name or should they own it or title it in a land trust or a living trust? Um, I have a keen interest in this. I personally have my real estate in a living trust, and we'll talk more about later on the difference between a land trust and a living trust and what are some of the benefits of it. I also thought this would be an appropriate class because there is so much unrest right now in the United States, and people are doing some crazy things, um, such as putting out to the public the fact that this is the address of police officers so that people can go to their homes and to do whatever they want, whether it's harassing, throwing rocks, Molotov cocktails, etc. So again, there's probably certain people that you all deal with, policemen, firemen. I know teachers, they get some upset parents at times that they just don't want their commonly known address to be in the public domain. And again, I'm probably going to be showing my age in a little bit here, such as when I had dark hair, there was no such thing as Google. Now, if I want to find Bill Uraski, I don't have to go too far other than go to either Google or just go to the recorder of deeds, and I can find deeds in his name. I can find mortgages in his name, and all of those documents have his address on it. And that to me is quite a scary thing because there's certain reasons that I or others would not want to have their address known to the public. I'd rather keep it private and give out my address when I think it's appropriate to the appropriate people. So there's been some fantastic advances in the field of electronic communication that's going to constitute a greater danger to the privacy of individuals. This was something that was said by Earl Warren. He was a Chief Justice of the United States Supreme Court, and he served in 1953 to 1969. What a perspective he had way back then. Here we are in the year 2020, and we've got the Chief Justice of the Supreme Court saying these electronic advances, you're going to be giving up some of your privacy as a result of this electronic communication. This is how people used to snoop on your property. They would get their binoculars out. They would look over the fence. They could do whatever they wanted to peek and sneak. Now it's just a computer. You just have to get on there. Like I said, go to Google. You can also go to the recorder of deeds of any county, and you would be able to bring up the deeds to properties. You'd be able to bring up mortgages. And again, let's take time to think about what is on a mortgage document. Well, it's going to be the dollar amount that they borrowed. It's going to be the date that they bought the property. It's going to have the value of the property. It's going to have the commonly known address of the property. There's nothing to stop someone. In fact, that's one of the ways that some of these companies who say, hey, would you like a list of people who recently purchased a home in the last year, if you wanted to see if you could refinance them into lower rates. They just go get public records from the recorder's office, and they then distribute it out to loan officers and to other people who might want to take advantage of that database. So again, today's electronics, electronic recordings, titling real estate in your individual name, you are giving up your name, your address, the amount you're borrowing, and the fair market value of your property by putting it into your individual name. So for example, recorder of deeds. The recorder of deeds is where the deed of the property on a real estate transaction gets recorded. The recorder of deeds will also record the mortgage. So again, those become public documents. They become part of the public domain. And again, I deal with certain policemen, I deal with firemen, I deal with teachers, I deal with just people who prefer that their property or their ownership remains private. Some of you deal with investors, for example. And maybe the properties that they're buying are not in the best neighborhoods there, or some of them might even be considered slum landlords. That's not something they necessarily want to be proud of. That's not necessarily something that they want somebody that looks at a property and says, well, that's not in the best condition. I wonder who owns that property. Well, rather than being able to find it through Google or the recorder of deeds, you know, if they put it into a land trust or a living trust, well, then their ownership remains private. Because you got to remember what's going to happen when somebody moves their title, when somebody takes real estate and titles the ownership into a land trust, into a living trust, the owner of the property is land trust number 1234 dated June 6th, 2020. So now somebody goes, well, I wonder who the owner is. Well, it's land trust number so-and-so. And the land trustee is usually a bank. It could be Chicago Title, could be Chicago Title Insurance Company. But largely it's banks. And they have no ability, they have no authority to ever release who are the beneficiaries of that land trust. And we're going to look at a land trust. It's not that complicated. We're going to break down the document so that you all understand how easy it is, how simple the document is, and it, you know, for people to title their property into a land trust. So again, the recorder of deeds, that's going to be the holder of all these publicly these documents that remain open to the public for review. And the last thing you really want to do is to let people who have a screw loose or people that have a vendetta against a policeman, a fireman, or your client, to let them know exactly where they live. Again, you think you're private. Well, look at all the different places where you're making yourself visible these days. Most of us have a Facebook account. Depends upon how much information you put out there on Facebook. Is your address in there? Google, National Security Agency, LinkedIn, Zillow. There's all these different electronic domains that hold information about you. It's somewhat a little bit scary. You're making yourself open to let anybody and everybody find out exactly where you live. When you title property in your individual name, you may as well send out an email to your coworkers, to the busybodies, to my high school class, to collection agencies, to the IRS, to the ex-husband's mother, to vendors, to ex-business partners and your scam artists, telling them, hey, I got a new home. And hey, everyone, I just bought a new home for $1.2 million. The address is 422 South Blue Street. My lender is Great Loans USA and my mortgage is $600,000. Thanks, Jill Smith. All of that information is sitting in the deed and in the mortgage that you just closed on, and that you took the title to the property in your individual name. Kind of crazy. You know, again, when we talk about costs, and don't hold me to this because I am not the bank, I am not the title insurance company, but to set up a land trust is like a $99 investment. So for $99, you can now, instead of it being in Glen and Rose Marino's personal name, their real estate, it's now in land trust number 1234 dated June 6, 2020. Well, people are going to give up when they see who the owner is. Well, they have no idea who that is. So again, if you're looking for and need privacy, and it should be something as a realtor, again, you're a great resource, but wouldn't it be great if you're also an educating resource? educating them that you could put this in your individual name, but if you're a person that wants privacy, and we're to see other people who use privacy, but maybe they're susceptible to being sued. We'll talk about that shortly. Maybe they would like to explore the option of a land trust. And whether you have a relationship with a bank, if you don't, I'm going to be sending out this PowerPoint to everybody after the class. Judy Meisner's contact information is at the beginning, is at the end. You can contact Julia, and she would be more than happy to set you up with a Chicago title land trust. So what is a land trust? Well, first off, what's interesting about it is there's only 8 states out of the 50 states we have in the United States that actually have land trust powers. It is Illinois, and then there's 7 other states. It's a form of holding title to real estate. And I'll show you what the document looks like shortly. The creation of the land trust is a 2-step process. First, you sign the trust agreement. And the trust agreement, the key features of the land trust is when you fill out the trust agreement, you have to name a trustee, which is typically the bank or Chicago Land Trust. You have to name the beneficiary. Well, typically the beneficiary is you, is the homeowner. In our case, the beneficiary is Glen and Rose Marino. And then you have to also put in the legal description of the property. And then what you have to do is you have to name who holds power of direction. Typically, the beneficiary retains all management and control of the property. It's a fancy term for they hold power of direction. The trustee, which is the bank, which is Chicago Land Trust Department, they do nothing. They sit on their hands until they get a letter of direction from the entity that has power of direction. So if Glen and Rose are not only the beneficiaries, but if they also hold power of direction, Glen and Rose would write a letter to the trustee saying, "Hi, it's Glen and Rose with power of direction. We hereby ask that you sign the mortgage for our loan. We just refinanced and we want you to sign the mortgage because you're the owner of the property. You, the land trust, are the owner." So again, the land trustee, being the bank or Chicago Land Trust Department, will do nothing until they receive a letter of direction from the entity that holds the power of direction. Then obviously after the trust agreement is prepared, they're going to deed the property into the trust, into the name of the land trust. It's not going to be Glen and Rose. So if I was buying my property from Bill Uraski, at the closing, we would ask the seller side, Bill Uraski's side, to prepare the deed from Bill Uraski to the land trust number 12345, dated June 6, 2020, and they would put in the legal description, etc. So let's take a look at the document. It'll make a little more sense when you see the document itself. So let's take a look at, okay, here's a typical land trust agreement. I've highlighted in yellow the 3 sections that you need to be concerned about. The trustee. The trustee here is First Midwest Bank. It's either a bank or it could be Chicago Land Trust Department. Then in the blue box here would be the legal description. You all have seen legal descriptions. It's, we're very easy for us to get the legal description and put it in there. You're gonna put in the tax ID number. You're gonna put in the commonly known address, 1234 Main Street. The next major yellow highlight is then who are the beneficiaries that are entitled to the earnings, the avails, the proceeds of said real estate. Down here is gonna be all your beneficiaries, which is where Glen and Rose Marino would go. Okay, pretty easy. And then who holds power of direction? Typically, it's going to be the Glen and Rose Marino are gonna hold power of direction over their real estate. But let's say, for example, that the beneficiary was some minor children. And again, you wanted to keep it private. You did not want people to know that, that they own the property, the parents could be holding power of direction, and the beneficiaries could be somebody other than the parents. But again, let's go back to the very simple. Let's keep this real basic. The trustee is going to be your bank or your land trust department. You're going to indicate who the beneficiaries are, typically, the homeowner, Glen and Rose Marino. And power direction typically will reside in Glen and Rose Marino. Remember what I said before, the trustee, in this case, First Midwest Bank, signs nothing, will not sign a transfer of the deed. If I was selling the property, will not sign the new deed that needs to be prepared until we, Rose and I, give them a letter of direction, because we hold power of direction, telling them to sign the deed. If we were refinancing, we would give them a letter of direction saying, you are hereby directed, as we hold power of direction, to sign the mortgage for whoever the new mortgage company is for First Centennial Mortgage, as we are in the process of refinancing. So again, the document after that is pretty much where do bills get mailed, where do legal notices get forwarded to. But I mean, it's pretty boilerplate after that. And then at the very bottom here, I think it's like a 3-page document. Again, I've seen them as little as 2 pages. This happens to be on letter paper. If you went to legal size, which a lot of the land trust documents are legal, it fits on 2 pages. So here comes, all 3 parties are signing. The trustee, First Midwest, signs, the beneficiaries sign, and the person's holding power of direction, if other than a beneficiary. So Glen and Rose would not sign down here, because we are not only the beneficiaries of the land trust, we also hold power of direction. So very simple. 3 things are needed. You need a trustee named, you need to have beneficiaries named, you need to have power of direction named. And usually the beneficiaries and the power of direction are one and the same. Okay. So the land trust allows people to do a couple of cool things. They own real estate confidentially. Okay, that's of great comfort to Rose and I, that people don't know whether we own 1 piece of real estate or 3 pieces of real estate or 10 pieces of real estate. It's none of their business. It's off the public record. They cannot find us when they go and do a Google search. They cannot find, if they were to put in the addresses of our properties, they would not be able to find that we are the owners of the individual pieces of real estate. They would, however, get to see that land trust number 1234, dated such and such, is the owner of the real estate, and they throw up their arms and go, well, that's going to go nowhere. It's off the internet. Again, when you go to Google it, the owner of record is going to show up as a land trust. And again, this might be a good time to talk a little bit of land trust versus living trust. The land trust, again, we talked about it being about a $99 cost. And again, it may have gone up. Again, I'm not the bank. I'm not the Chicago Land Trust Department, but it's not a huge cost. And just by the word land trust, it only holds land. It only holds deeds to real estate. But again, what is the largest asset that most people have in their net worth? Well, it's real estate. So again, a land trust is a great place to begin. I mean, having no trust is where everybody starts. But the first building block to it is go to a land trust. It's inexpensive. It doesn't cost much. Yet it gives you privacy. It gives you, and we're going to talk also about probate court in a little bit. But from a privacy point of view, you got all the privacy that you want for a nominal cost. The living trust, however, is something that encompasses not only your real estate, but if you had other assets. Let's say that you had mutual funds, stocks, bonds, annuities, and you wanted to put all of your assets now into a trust so that you, upon your death, you could direct them to beneficiaries or to your children, and that you could say, well, my children are only going to get a third of it up until the time that they're age 30, and then they'll get another third when they're 40, and they'll get another third when they're 50. You can do all those crazy things when you have a living trust. And the reason that most people don't immediately jump to a living trust is because of the cost in establishing it. It's going to be, $2,500 to, maybe $3,000-$4,000 to set up a living trust. So until you have accumulated other assets that are other than just real estate, land trusts fill a huge, great service to you from a privacy point of view, and then it's going to help you avoid probate court costs, and we're going to talk about that shortly. So again, having a land trust is like having an unlisted address, or it's like having a star 6-7 for your real estate. If you ever used your smartphone or your phone at home and you dialed star 6-7 and then dialed the phone number that you're trying to reach, person on the other end, the caller ID is going to show up as a private number. It's not going to identify Bill Uraski or somebody, whoever's calling. So again, same thing with a land trust. It's going to be a private address. It's going to be a private, no one's going to know that you own the real estate. And again, I go back to the investor. If you have investors as clients, if they're not putting them into a land trust, do they really want everyone to know that they own all the different pieces of real estate? The side effects of toxic transparency in real estate. Well, it's a loss of physical safety. What I mean by that is if people know your address and you're in a profession that, people might, such as a policeman these days, that your physical safety could be at risk if your commonly known address is easily available through Google or the Recorder of Deeds. I could get to a lot of policemen right now. In fact, whenever I give this presentation at police headquarters, I get almost everyone in the room to sign up for a land trust. There is no doubt for $99, or even if it's gone up to $100 and some dollars, they want their privacy. They don't want the public to know where they live. An increased exposure to litigation. Let's say that in your lifetime, you start to buy your primary residence. That's typically your first piece of real estate. Then all of a sudden, your second piece of real estate might be a second home. You say, oh, gee, Colorado is really a great place. I'd love to have a second home out there in Colorado. So you buy that some years later. And then as you get even older in life, you say, you know what? I'd like to get some rental property. I think I'm going to buy a single family and I'm going to put a renter in there. So you end up with 3 pieces of real estate. It's not uncommon by the time you get to be my age that each piece might be worth $300,000 a piece. That's 3, 6, 900 round. You got $1 million worth of real estate. Well, what happens if for some reason you get into a car accident and you hurt someone, and now they get a judgment against you for damages, and it goes beyond, let's say, the limitations of your insurance policy? So they're going to get a personal judgment against you. And what are they going to do? They're going to attach it to your assets, unless it's in a land trust, because you don't own the real estate when it's in a land trust. The land trust is the owner. So when somebody comes along and wants to attach a lien, a judgment on your assets, they better look to something other than your real estate if it's in a land trust, because you can't attach it. It is not your asset. You're just a beneficiary. The loss of financial safety. Again, we just talked about it. What would happen if, again, you went through life and you've accumulated $1 million worth of real estate, and all of a sudden, it was, just an unforeseen act of God. You got into that car accident, and now all of a sudden you get slapped with $1 million, a $500,000 judgment. And now all of a sudden you're going to see a lifetime's worth of accumulating assets and net worth all of a sudden go up in smoke, because it is now a personal asset that someone can attach a lien or a judgment to. However, if you had spent $99, you would have safeguarded that lifetime's worth of investing in real estate or accumulating assets. I think it's a small premium to pay. And there is an annual renewal fee to a land trust. And it could be not the $99. Again, you'll have to check with the bank. You'll have to check with Chicago Land Trust Department. But you're going to have an annual fee. And again, it's going to be nominal. But what a nominal fee, what a nominal premium to pay for peace of mind, for both physical safety and for the reduction in exposure to litigation and financial safety. The disclosure of sensitive data. What I mean by that is you're going to have sensitive data could be that you're owning or you're investing in real estate in a area that you don't want people to know. Again, goes back to the slumlord concept. Do you want people to know that this doctor, this lawyer, this investor is investing in a particular area? Let's just go away from the slum landlord idea. What happens if you're trying to accumulate real estate because you want to knock it down and you want to build something else? It happened to me out in Denver, Colorado. There was a developer that was buying up single family homes. Well, if all of a sudden the first home was in the name of the developer and the second home closed on was in the name of the developer as the buyer, and wouldn't the neighborhood then, wouldn't they all of a sudden start asking for a higher and higher price, knowing that this developer is trying to accumulate and purchase all these different parcels so he can knock them down and he can put up different type of housing or go get the zoning changed and put up a strip mall or whatever his intended purpose is. But again, it's going to help to not disclose sensitive data as to who's buying real estate or who owns real estate in a particular neighborhood. And again, the loss of bargaining power, that goes back to, again, accumulating, that developer, if he's trying to buy real estate at a reasonable fair market value, but then all of a sudden they see that he's bought parcels 1, 2, 3, and 4, then parcels 5, 6, 7, and 8, he's not going to have a lot of bargaining power. They know that he's the guy that's been buying up the neighborhood. They know he's the one that, but if it goes into a land trust, they have no idea. And again, they could be in, you could have a separate land trust number for each one of the parcels, so they don't realize that, well, it's land trust number 1, 2, 3, 4. Well, that might have been parcel 1. Parcel 2 could be land trust 3, 4, 5, 6. And then the next parcel could be land trust number 7, 8, 9, 10. So again, you can have different land trusts such that people don't know who's buying the real estate, and you don't lose your bargaining power to bargain in good faith and get a purchase at a reasonable price. So who benefits from a land trust? Well, it's anyone who keeps the details of their purchase transaction off the internet and keeps ownership of their real estate holdings confidential and shielded from public view. We've talked a lot about that so far. So it's really anyone who wants privacy. Who also benefits? High-profile individuals, celebrities, athletes, such as Michael Jordan, media personalities, political figures. Perhaps they don't want people to know that they just bought a particular piece of real estate. They don't want the media cameras and the neighborhood and everybody, converging on them. They don't want it in the public domain. High net worth individuals, homes worth $500,000 or above. Again, perhaps they don't want people to know that, oh, look at this individual. They just bought a $750,000. They bought $1 million home. Again, there's reasons for people that buy bigger properties. They don't want people to know that they own $1 million homes. Who also benefits? It's subject to any profession that is subject to liability. Physicians, don't doctors get sued for malpractice? Don't attorneys get sued for malpractice? Don't accountants get sued for improper audit procedures? How about small business owners? Don't they get sued also? So you got a whole set of people that could be sued, and those assets that are in their individual name, personal assets, could be liened on, could have judgments assessed against them if, when they're sued, the courts find in favor of the plaintiff. But if it's in a land trust, they don't own the real estate. Could be a great reason for you to be an educating realtor to get their property out of their individual name and into a land trust. Safety issues. It's in the news every single day. We've got first responders, law enforcement, firefighters. They're under attack right now. They're under attack on the streets. Do you think they would like to go home and think of their home as being sanctuary? Well, not with today's electronic communications, not with Google, not with the recorder of deeds, because anybody with a screw loose can easily find out, hey, I saw Glen Marino's badge out on the street today. I saw he's a law enforcement guy. I don't like that guy. He yelled at me while we were out in the streets. He pulled me over for a traffic violation. I don't like the way he handled me. I saw his name, Glen Marino. So he goes ahead and he Googles me and he finds out that I own real estate. You know, I have two houses in the Chicagoland area. He decides to throw a Molotov cocktail or a rock and endanger my wife and my children. I'm not sure that I really want, if I was a law enforcement person, I would want my property in my individual name. Again, here's a mystery buyer that pays $7 million for a Wilmette house. But it's interesting because if you read the red box, it says the site was the third high-priced sale in the past 6 months on that block. It's the third parcel in the last 6 months whose homes have private beaches. In all three cases, the records show the buyers were land trusts and were shielding the buyer's identity. So again, could this person be trying to buy a private beach locations? Maybe they're going to develop something on the private beach property. But again, they did not want people to know. Could have been 3 separate individual land trusts, such that if he was going to go and try to negotiate or purchase another property, it wouldn't be known that it was that developer that was really trying to buy up all the private beach property down there. And again, if you look at Chicago Cranes, they will publish from time to time Chicago's priciest home sales. If you looked up any of these, you'll probably find that the majority of them are held in a land trust because, again, people do not want people to know how much real estate they own and what it's actually worth. So we've taken care of the privacy part of it. The second half here, and this is probably one of the last slides, is land trusts also provide you with a huge savings because it avoids probate court. So let's talk a little bit about probate court. Probate court, if you, in the state of Illinois, if you have over $100,000 worth of assets, well, if you own real estate, even just one piece of real estate, most of the time it's going to be worth more than $100,000 at your death. So if you own more than $100,000 worth of assets, if you have no will, there's 3 columns here, no will, a will, or a living or land trust. With no will or a will, you're going to go to probate court and you're going to sit there for 9 to 12 months before your property can be sold and distributed. Probate court does not work for free. You're going to see that shortly. They work for anywhere from 3 to 8%. Let's use middle of the road, 5%. Let's use my example again. As a young man, I bought my first home, primary residence. As I got a little bit older, I said second home in Colorado would be a great idea. As I got a little bit older, I said, you know what? I want to be an investor. I'm going to buy a rental property, single family, put a tenant in there. And then when I passed away, I had 3 pieces of real estate, each worth about $300,000. 900,000, say $1 million, because we can do this in our head. What's 5% of $1 million? That's $50,000. So if your real estate is in your individual name, your plan upon your death is not to pass through 100% of your assets to your children, to your charities. You're going to give up. Your plan is to give up $50,000 in my example. People say, oh no, that's not my plan. Oh yes, it is your plan. It's your plan because you continued, when you pass from this earth, there's only 3 ways you can pass from this earth: with no will, with a will, or with a trust. Those are the only 3 ways you can pass from this earth. And so my wish for all of you is that you either go to a land trust for a nominal fee, or if you have other assets, spend the $2,500, $3,000, $4,000 and create a living trust. But let's just say that you go with the land trust. With a land trust, there is no waiting 9 to 12 months. Within 2 weeks, your trustee of I call it your successor trustee, because initially you're the trustee of your own living trust or of your land trust, but your successor trustee will end up then distributing your assets, could be within 2 weeks after your death. There is no waiting around for 9 to 12 months. And why do people have to wait 9 to 12 months? Because if you die with no will, then according to state law, your assets are going to be distributed, to your dependents, to your wife, to your sons, to your daughters. So it's going to just follow your lineage. But again, what the courts are going to do, the reason they wait 9 to 12 months is they're going to put it into the newspaper. They're going to let everybody know. They're going to give a public, there's going to be a public notice made that Glen Marino just passed away. He passed away with no will. What that means, if I have a unbeknownst to me living in Las Vegas, and he sees the legal notice, he can raise his hand, come into court, and say, well, I'm the illegitimate son or the legitimate son of Glen Marino. And then, depending upon what others think of it, the trustee can then fight it, contest it, or, given the proof that that is actually my son, add the son to the list of people that are going to get a portion of my assets. So again, they allow 9 to 12 months for people to raise their hand when there's no will and say, I belong into the lineage, I belong into the heirs of Glen Marino. I just haven't been around for a while. I haven't let people know I'm around, but now that Dad's passed away, I just want to let you know that I'm his legal son or his legal daughter. When people pass with a will, it's the same 9 to 12 month period exists in probate court, allowing the will to be contested, because your will can be changed at any time, right? So on Dad's dying bed, Dad whispered, Dad has 6 children. I'm one of 6 children. My dad whispers into the ear of my sister, I'm leaving 100% of my assets to you, Nancy. Well, maybe the other 5 brothers and sisters think that's wrong. Maybe they think Dad was not of sane mind. Maybe they think Nancy did something not so nice. So what they're going to do now is there's going to be a contest over the will. And so that allows that 9 to 12 month period. It could go longer, depending upon how long it takes to contest it. But that's the point, is that there's a 6 to 9 to 12 month period that the courts leave open your will for contests to be filed. And again, while they're holding your will open and not distributing assets, they're charging you 5% on average of that $1 million worth of real estate. They're charging you $50,000. I don't know about you guys, but that's not my plan. I don't plan to give up $50,000 of my assets when I could have spent $99 and put my property into a land trust and have my assets distributed according to the document itself. So let's just take a quick look at probate, no will, and a living trust. At incapacity, courts appoint a court appointee oversees your care, must keep detailed records, reports to the court, and usually must post bond. Court approves all expenses, oversees financial affairs. Same thing with no will. So the court, the probate court, if you're at incapacity, you lose your mind, etc., Alzheimer's sets in, you're going to get a court-appointed person to take over your assets. With a living trust or land trust, there's no court control. Your successor trustee manages your financial affairs. At death, okay, that's probably more common for all of us rather than the incapacity. At death, the court orders your debts paid and your assets distributed according to the state law. Okay, that makes some sense. Again, it's called, all your heirs are going to get, their proportionate share of your assets. Same thing with a will. But your assets will be distributed per your will, if valid, and any contests are unsuccessful. But again, when we get down to the time frame down here, you're going to see that this distribution at death does not happen immediately. It takes place some 9 to 12 months later. Court costs, legal and executor fees. If you die with no will, it's often estimated at 3 to 8% of your estate's value. Again, go back to my example, $1 million worth of real estate and any other assets that I have. So again, take the middle of the road, 3 to 8%, 5% of $1 million, that's $50,000. Not my plan. Hopefully it's not yours. Same as no will. If you die with a will, again, people think, oh, I got a will. Oh, great. You're still going to probate court. You're still giving up $50,000 in my example. Is that your plan? If it's not your intended plan, then change it. Because again, your costs can increase if the contesting of your will goes on and on beyond 9 to 12 months. Time, again, over here under a land trust at death, usually there's no estate, there's no estate taxes. There is no court costs. And again, at death, there is no probate. The debts are paid and the assets are distributed by the successor trustee according to the instructions in your trust. Cool. That's what you want. I don't want court costs and I don't want delay. My document speaks for itself, who the beneficiaries are and who the successors are upon my death. That's fantastic. Again, we time frame at death, usually 9 months to 2 years before heirs can inherit. Wow, up to 2 years. That wasn't my intended plan. I thought that when I died, my assets would be distributed. But again, it just depends on if anybody raises their hand and says, I am also an heir of Glen Marino. With a will, same as no will. It's going to take anywhere from 9 months to 2 years. I've been saying 12 months, but not 9 months to 2 years. If there is a contesting of the will by any of the children or by anybody else that says I should have been included in that will, that the will was, fraudulent, or that the dad had signed the will when he was not of the sane mind, and now you get the courts to decide whether that's true or not. If you have a land trust or a living trust, it's just weeks usually, the time frame. Larger estates may take a little bit longer, but it's usually just a couple weeks before all of the accounting is done and you're able to distribute the assets. Flexibility and control. There is none if you die with no will. The court processes, not your family. The probate court will process. They have control at incapacity and at death. When you die, assets are distributed according to the state law. If you die with a will, you have limited flexibility. Same as no will, except when you die, the assets are distributed according to your will, because there's where you have some control, if the will is valid and if any contests are unsuccessful. You can change your will at any time, provided that you're of sane mind and someone doesn't contest it that you were insane or not of the right mind when you changed your will. Again, what happens with flexibility and control on a living trust or a land trust? You got maximum flexibility. You can change, discontinue your trust at any time. Assets stay under the control of your trust, even at incapacity and after your death. It's more difficult than a will to contest. Lastly, privacy. If you die with no will, you don't have any privacy. The court proceedings are public record. Family can be exposed to disgruntled heirs, unscrupulous solicitors. It's going to be all over, it's public record. You're going to see that, one sister is suing another brother. Same as no will. There is no privacy, even with a will. If there's contests that are going on, the legal proceedings are a public record. If you have a living trust or a land trust, they are not public record. Your family can take care of your financial affairs privately. So, my friends, I thank you. If there's any questions, feel free to unmute yourself. But the two main points to pay attention to here today is the fact that for a nominal fee, you have what's called a land trust that will keep your affairs private. People will not know where you live, will not know the address of your real estate. Secondly, you will avoid probate costs, which could run up to 5% of the value of your assets or more. In my example, it was a $50,000 cost. That is not my plan, and all I can do is wish for you that it not be your plan. So if you do have any questions about land trust, please feel free to text me, call me, email me, or you can contact, I'll be sending out this PowerPoint. You can contact Julia at Chicago Title Land Trust. She's a wealth of knowledge. You can go to your local bank where you have a checking account and ask if they have a land trust department. If they do, they can also further educate you. Remember, a land trust document is maybe 2 to 3 pages long. It's not a complicated document. It's got 3 things in it. It's got the trustee in it. It's got who the beneficiaries are of the land trust, and it's got who holds power of direction. Who is directing the trustee to assign out deeds? Who's directing the trustee to sign mortgage documents? The trustee does nothing without a letter of direction from the entities that hold the power of direction. Let's just take a quick look to see if we've got anything in the chat box here. Yin Yan, I don't have the audio yet. I just left HomeSmart Zoom meeting. Ha ha ha. All right, well, we'll make sure that Yin Yang gets a copy of the recording so that she can take a look at this. You guys have been great today. I want to let you know that my team under Tony Marino, who's the branch manager at First Centennial, stands ready to help any of your clients with scenarios, with financing. Tony can be reached at his email at t.marino@gofcm.com. You can also be reached by telephone at area code 847-804-1059. You all have been great today. I appreciate you. Let's grow together. Have a great day.